SJC-13227, Commonwealth v. Will Tate.
Okay, Attorney Feinberg, whenever you're ready.
Good morning. Excuse me. May it please the court. Matthew Feinberg representing Will Tate, the appellant. Some 6 months after the fatal shooting in this case, the mother of the defendant in her basement discovered a green box that we eventually found contained what we now know was the murder weapon, as well as some stray bullets, a laser attachment, and the defendant's
Mr.
jacket.
Feinberg, I'm going to cut you off from the facts because it's a very interesting issue, an important issue you raise in your brief, so I've got a few questions.
Happy to go straight to it, Judge.
Great, thank you. Assume I agree with you that there was a violation of 1.6, that despite no absence of guidance and in good faith, I think, by the lawyer, he violated 1.6. The way I read your brief, you have a per se ineffective assistance of counsel from the violation of 1.6, and I want to ask you about that, where at least in like the conflict of interest area, where there's at least in the conflict of interest area, where there's an actual conflict of interest, we say we don't get into prejudice and it's a per se violation, new trial. With potential conflict of interest, we don't do that, we go into prejudice. There are other cases we've had where we look at professional responsibility lapses. We say that's evidence of ineffective assistance, we go into prejudice. So why in this case do we not look at prejudice?
Well, I think you can look at prejudice, but per se.
I want to know your view. Like, is this a prejudice inquiry or not?
I would submit, Judge, that this is a per se case. The reason it is because what the defense counsel did was such a dramatic violation of the whole foundational element of the criminal justice system and turned the entire case on its head, that the very fact of the violation under 1.6 and the absence of informed consent, and I can get to that in a minute, makes this a case in which, in effect, there is ineffective assistance.
Okay, then how do we go through the professional conduct rules and to figure out which ones are per se and which ones require prejudice? Because there's a case called Duarte we decided not too long ago where there was a violation of failure to inform a client to make a meaningful jury waiver, and we looked at prejudice in that case. So what is it about the 1.6 that makes it per se like an actual conflict of interest?
Well, I think that the clear implication is that in this case, we're talking about the constitutional rights of the defendant. The effect of this disclosure was to the effect that his choice whether or not to testify was completely eliminated.
I'm not so sure I buy that because and I know you have an issue with the motion to suppress, but we have statements to the police. He really doesn't have anything other than self-defense, and he's going to have to testify. That's before Attorney Atwood tells the police.
Well, it may be, and I will say that the self-defense was probably the best approach in this case. Nonetheless.
And he got a second.
I'm sorry?
And he got a second-degree
Well,
conviction.
he got a second. He might not have gotten a second. He might have gotten a manslaughter if it wasn't for this. Because what we have here is a situation in which if he had not testified, if there was no disclosure, he still had a viable self-defense case.
You think there's a self-defense instruction if he doesn't testify?
Absolutely. Under these circumstances where what happened here was that there was an initial confrontation between the victim and the defendant where it was clear from the video that the victim was the aggressor. And then the defendant leaves, the victim goes upstairs 15 flights. He believes at that point that his sister is gone with the defendant, and he runs down 15 flights of stairs, comes out into the open area with what appears to be a black object in his hand.
How do you get the evidence of the black object?
I'm sorry?
The evidence of the black object comes from another witness?
No, it comes from the fact that when the victim is found, there's a black telephone in his hand. On those facts alone, it seems to me that a judge must give a self-defense instruction.
I don't know about that, but.
Well, maybe we disagree, but I'm suggesting to you that that
I don't know,
would
if
necessarily be
if
the
everybody
case.
that gets shot with holding a cell phone gets a self-defense instruction, I don't know about that.
This is 12 o'clock or 1 o'clock in the morning, it's dark out. There's at least a strong basis here for it.
But let me, and then I know it's
Yeah,
just,
I'm
but
sorry,
let
go
me just
ahead.
finish up with you as far as the importance of the 1.6 violation. I just want to give you a full opportunity to answer that question, because we went off on a little divergence on prejudice, but
Well,
can you
if we-
finish your answer on that?
I'm sorry?
If you didn't, can you finish your answer on
Well,
that?
I mean, in response to Your Honor's question, we could go either way in this. It seems to me that if you reject the per se argument, you can go to the prejudice argument, and the prejudice argument, it seems to me, is overwhelming here.
All right, now let me, on the prejudice point, how does the attorney handle the prospect of the mother disclosing during the trial? Because he has the time bomb of the mother, and he basically takes the evidence and spins it and says, oh, the Braga Bridge lie was to protect his mother. So he spins it the best he can. But you have that whole issue of if he's got his client on the stand, he's got to think in the back of his mind, this whole thing may blow up because mom is going to tell the police the gun wasn't thrown off the bridge.
First of all, he could have and should have simply suggested to mother that she get CPCS counsel. That was the simple way to do it. The record reflects that she did go to see a lawyer, and the lawyer refused to represent her without being paid.
He said to go get a lawyer, and
Well,
then that doesn't, you
I
think
know
you think
from-
his duty was to say, go see CPCS?
Well, I know from my own experience in many cases, and I'm sure the court, and when you were sitting on the Superior Court, had the same experience, that many times a witness, whether it's a Fifth Amendment issue or otherwise, has separate counsel, and in this case, that would be the case. Otherwise, it seems to me that the issue of the mother
So does she have the
is
right to
completely
counsel?
speculative.
That's a question for me, because I read the California case that someone cited, but, so will she have a right to counsel? Because if she's indigent, how do we deal with that?
I would suggest that, first of all, she is indigent, but
But again, she's not the defendant. The defendant has a lawyer. Does she have the right to counsel here?
I believe she does, Judge. If for no other reason, then there's a potential here for her being an accessory. She has possession of these incriminating items, and what is she going to do? That's a problem.
But do we give lawyers to people who,
I'm sorry.
do we give lawyers in that instance? There's no case.
I'm sorry?
Do we have a procedure to give lawyers in that instance?
As far as I know, I don't know. That's a good question. I really don't have the
Is there an
answer to that.
exception based on a family member being charged with as an accessory?
Again, I'm sorry, I didn't hear that.
I'm wondering, I thought there was some kind of exception for a family member who may be charged with accessory, especially a parent. I don't,
Could be so.
okay, we don't know.
Okay, so-
Are you acting on behalf of CPCS in this case? I can't remember. Are you private counsel, or has CPCS taken a position on that? I mean, I'm just curious.
I don't know. I really don't know. the
Well,
answer.
yeah, the CPS brief says Atwood should have withdrawn. Correct? Well, I don't know if you read it, but they said your brief is fine, but they said he should have withdrawn. Is that really a solution? Because it just kicks the
Yeah,
can
I
down the
think-
road for the next lawyer?
I think one of the solutions in this case is that for counsel to withdraw.
Well, counsel, wasn't there a solution in that the proper thing is Attorney Atwood cannot put himself in a position where he could obstruct justice.
Correct.
But the communication around the gun is different than the actual evidence of the gun and the bullets and whatever else is in the box. So isn't there arguably a solution in that Attorney Atwood turns or helps her turn over the gun but does not reveal the communication.
My response to that would be that there's a bright line when it comes to whether or not the attorney has actual possession. Without actual possession, I don't think that he can do that.
So
In
if
other
somebody had
words,
left the
idea-
gun, if somebody had just dropped it off at his office and he didn't know who, then he could call the police.
Absolutely.
And turn it over and say, and if it
Abso-
said, had a note on it, this is a gun belonging to so-and-so.
Well, as the amicus brief points out, there are a bunch of thorny issues relating to what happens when the attorney does have possession.
But I guess I'm getting at, we're not talking about the physical evidence, we're just talking about the communication.
That's correct.
Okay.
And this is a gun that has a body on it, so to speak.
I'm sorry?
This is a gun that is tied to a murder, right? So if the gun goes to the police and they test the gun, you're gonna have a problem.
That's correct. And that's exactly why the possession issue is so important here. I'd like to speak, if I could.
But before you leave that, because, sorry, are you done, just?
Yes, yes.
So the California case says attorneys who, you can't sort of take it away, but you can leave it in place, right? That's the California solution. I'm not sure that's a good solution, but that's their solution. But here we don't have, that exists as a possibility. The lawyer just sits there and does nothing, right? He doesn't withdraw. Once he takes possession, that's a whole different matter, but.
Exactly. And I don't think the court needs to get to that point in this case. There is no possession in this case, and therefore,
Well, but it's relevant to know whether he could have or should have as an option that he had available to him and how to handle the situation. Because he could have obtained it from the mother and returned it in without revealing the communication.
that's an interesting question, and I would suggest to the court that under the circumstances and under the rules of professional conduct, he could not do that, and that would, the information is there, whether or not he actually takes possession of it. You can't take away the fact of his being
No, I'm just
informed.
trying to sort it out for future cases.
Okay.
But once he turns the gun is very damning. It's got this laser on it. It's been stolen.
Exactly.
Once the gun is in play, it's harmful. But it's tough.
Well, that's exactly Attorney Atwood actually admits that in the hearing. He actually says this would be a different case without the gun. And he admits that in his testimony in the hearing on the motion for new
Because
trial.
the judge never reaches the issue of prejudice. She just says there was an effective waiver and it's over.
Essentially, what the lower court judge says is she assumes confidentiality and goes straight to informed consent. I'd like to speak a few minutes, I don't have much more time, to the informed consent issue, because I think it's important to point out that the defense counsel said, I believe this is my ethical obligation to disclose this. And when he says that, he's essentially saying, I don't have any choice in this matter.
No, I think respectfully, you don't have to argue much about this one.
And the rest of
So, I agree with that, but let's go to the prejudice for a moment. I know the judge didn't reach it, but perhaps, I think one of the reasons that the discussion came up about withdrawing is because Attorney Atwood would be limited on what he could ask his client when the client's on the witness stand.
or certainly even explain to the client that he cannot lie on the witness stand, and therefore his choice as to whether or not to invoke his Fifth Amendment privilege is somehow circumscribed.
Right, it's all the Nix v. Whiteside and our Miranda case, I think, that follows it. So how does that impact prejudice here? Because he would have been limited at trial, and it might have had to have been testimony in a narrative. Assuming that, and it may be otherwise, assuming that there's no ethical obligation to withdraw, how does the limitation on what can be elicited and the required advice on not committing perjury play into the prejudice issue?
Well, I don't see how you can avoid the situation where he is stuck with the idea that the defendant cannot lie on the stand. He either has to tell the client that he's going to give a narrative or not to testify at all. I don't see how you avoid that situation. It seems to me that the only other option that defense counsel would have would be to say, look, I can give you real informed consent. You have to decide. I can turn this over. We can have a informed consent. We can have a self-defense. You're going to have to admit the lie on the stand. All of this about the stolen gun is going to come out. Same thing with the text message on his phone, which the judge allowed a motion in limine unless the defendant testified. All of that would come out, and if the defendant still said, look, I want to testify and I understand all these consequences, he could stay in the case. It seems to me that that's a distinct possibility. However, on the other hand, the cleaner way to do this would be for him to withdraw and allow new counsel to come in without this knowledge.
I'm just trying to figure out as a practical matter how this works.
Say that again?
I'm trying to understand as a practical matter how this works. So I get the possibility where as soon as the mother comes to him, he says she's got to get her own lawyer, go to CPCS and get another lawyer. If he'd stopped all communication right up front. But I don't understand how this is, besides this, he seems to have, if what he did was okay, he's done it as good as possible. The only alternative I see that is the mother getting their own lawyer right up front. Is there a third possibility? I mean, Justice Cipher's proposal also seems to raise seems to make it worse in certain ways because he's got possession over the gun.
Well, I mean, one thing that could happen is that she simply doesn't do anything. She could simply not do anything.
Isn't that untenable from the lawyer, though, if you have the witness, if you have the client on the stand and you have the looming prospect of the mother blowing your case up?
I don't think it's any different from any other inculpatory evidence that a defense lawyer gets in the course of his preparation. He goes out and he finds a witness that says, I saw the shooting. Does he have to disclose that to the prosecution? The answer, it seems to me, is absolutely not.
I don't think it does. It seems to me too, but go on.
Well, I think that's the same issue here, that the mother has a choice what to do. She can protect her son by not doing anything. She can go to a lawyer, try to figure out what it is that she's supposed to do or may do.
I'm just, my only concern about the withdrawal advice is it takes Atwood off the hook, but what about lawyer number 2? Who comes in and all of a sudden we get the same issue where the mother says, hey, I told the other lawyer we got the gun. Now what?
Well, the real question, I suppose, is whether or not the second lawyer gets that information. That's, in this case, it seems to me that's just speculating as to what the second lawyer is going to have knowledge of.
The second lawyer is going to talk to the mother, and based on the representations everyone's making here, the mother's very religious. She's not going to,
She wants the gun out of the house.
wants the gun out of the house. She's not going to lie about this. I mean, withdrawing just seems to shift the problem to the next lawyer. I don't know how that works.
Just so I'm clear, this is all speculation, right? Doesn't this really just turn on whether or not there was prejudice based on what the lawyer did? I
Yes.
just want to make sure.
As far as my position is that, at the very least, virtually the entire trial was poisoned by this disclosure. Everything from the opening statements to the stolen gun to the laser attachment to the closing arguments, the entire case. In fact, the Attorney Atwood at the very beginning of his argument says, I spoke to the mother, she told me about the gun, I turned the gun over.
That assumes that you have to show prejudice. That assumes you have to show prejudice. Your first position is this is per se ineffective.
Right, but it's also, I'm not giving up on on the prejudice issue at all.
Shouldn't.
We're not asking you to.
Counsel, can I ask you, there's a case in Ray Grand Jury, and I know it's a subpoena, and it's involved a cell phone and documents on the cell phone, and what the attorney should do with that. Does that have any relevance, do you think, to your
Well,
case?
I believe that's the case in which the attorney had possession of the cell phone.
Yes.
And I think that really is the bright line here. Once the attorney has possession of it, or whatever it is, and it's inculpatory, he has obligations to the court, he has obligations as an officer of the court that are, that balance, if not overwhelm, his duty of loyalty and zealous representation of the client. In my view, that's the only way to interpret that kind of inculpatory evidence.
Okay.
Anything
Thank
else? Thank you very much.
Attorney Nadeau.
Thank you, Madam Chief Justice. Good morning. May it please the court, Stephen Nadeau, Assistant District Attorney for the Bristol District on behalf of the Commonwealth. I'd like to begin by addressing directly the question the court posed in its solicitation for an amicus brief. First, the information that Attorney Atwood received in this case was confidential. I agree with Attorney Feinberg that there's a distinction between if Attorney Atwood had received actual physical possession of the gun versus just information from the defendant's mother about the gun's location. But where it is just information, that information was confidential, and generally there is no obligation to disclose that to the Commonwealth. In fact, quite the opposite, except as the rules and the circumstances of any individual case might permit or indeed require. And it's one of those exceptions that this case falls into.
You're arguing meaningful consent?
I'm sorry?
You're going to argue meaningful consent?
Yes.
Okay.
Well,
The letter basically says, I have an ethical obligation to give this to the police, right?
correct.
So how is that meaningful consent? It's a fait accompli. He says, I'm going to give it to the police.
My understanding or my reading of the letter is that Attorney Atwood is expressing, I believe it is my duty to disclose. He also testified at the hearing that he absolutely unequivocally gave the defendant the choice. But of course, we don't know what would have happened had there been any disagreement, because Mr. Tate, in fact, signed the letter.
Because I thought the tone of the letter was, don't lie to me anymore.
Certainly, Attorney Atwood, I just was not happy about.
No, but that's what the
finding
letter
himself.
says.
I don't know that he says that exactly.
Well, but he does say, I'm charged, or this is the situation, I'm charged with giving you legal advice. My legal advice is that I have an ethical obligation to disclose this to the police. Sign here, I'm very mad at you.
Yeah.
And I think
How is that, as somebody who isn't informed with the legal system and relying on counsel for this legal advice, how is that now turned on the head and saying, oh, well, it was your choice?
Well, first, I would suggest that Attorney Atwood was accurate that disclosure was required on the unique circumstances of this case. As he described, you know, he was looking at the case as a whole. He knew that the defense was going to be self-defense, and early on realized there was no way to advance that claim without the defendant himself taking the stand. And then, thus knowing that, he knew that the circumstances of how the defendant obtained the gun, how he disposed of it, would inevitably arise, whether on direct or on cross-examination. And thus, Attorney Atwood had an obligation to be sure that his client did not testify untruthfully.
It's the duty to the client that the rule speaks to. And when the letter says, and I agree with you that the information that he had probably indicated that the defendant had to testify, and he's got legitimate concerns about what's going to happen with the ticking time bomb of the mother in that information. But even with all that said, the rule says it's a duty to the client, and the lawyer is saying, I'm going to take a course of action, period. Do you agree? Or I'm letting you know. I mean, it's not the client's decision whatsoever when you read that letter.
Correct, but, well, in addition to the letter, there was also a long discussion with the defendant where it was made clear that decision was ultimately up to the defendant himself. Again, the letter itself was phrased in stronger terms, but the motion judge was also the trial judge, specifically credited the testimony of Attorney Atwood in its entirety.
So we basically have to look at the transcript of that hearing, which
Yes, which is,
no, I've read it, and say that what was said in the transcript, given Judge Dupui's findings, basically makes the letter really a nullity.
I'm sorry, repeat that last part?
It really you can't read the letter, I think, and say there's any meaningful consent. But what you're saying is, let's look at what Atwood said, what the judge found credible, and that's gonna
Right, there was a
that's
meeting,
gonna
there was a
carry the day for
discussion
you.
that went beyond the four corners of that letter. I don't think Attorney Atwood testified that the discussion was just him reading the letter out to Mr. Tate. There was a discussion that went beyond that, what they should do with the case as a whole. And, aside from the ethical obligations, the specific factual circumstances of this case, the overwhelming evidence of the defendant's guilt, even before getting to his numerous admissions to having shot Mr. Rodriguez, it was best to get out ahead of the potential ticking time bomb of this coming out, either for the defendant testifying truthfully, but concealing it until he's on the stand and then sending the sort of prosecution into a tumult of trying to track down this gun that's now out somewhere that they thought has been tossed over a bridge. Or perhaps even worse, having the defendant's mother, I think at one point in the testimony, Attorney Atwood speaks to a concern that she would erupt mid-trial, which of course created a devastating bombshell moment that would more gravely undermine the defendant's credibility than getting out in front of the issue, as Judge Dupuis found, and allowing Mr. Atwood essentially to argue, look, notwithstanding that initial untruth about the Braga Bridge, my client has been truthful. He was on his way to turn himself in when he was arrested. He's never denied that he shot Mr. Rodriguez, and indeed, now in the heat of the moment, he may have said, I threw it off the Braga Bridge, but they now found the gun, the Commonwealth found the gun because we gave them that information and allowed him to say he was being honest. Predominantly throughout these proceedings, he's being honest in his testimony when he says that he fired in self-defense. So in view of that whole circumstance, it was a reasonable tactical decision, sort of separately from the ethical analysis.
What do you do with the, sorry, I didn't, no. What do you do with the California solution? The California solution says if he's in possession, then he's got to turn it over. But if he's not, he doesn't have it, he can leave things where they are. I mean, I'm just wondering, when he says, I believe it's my ethical obligation to turn this over, I don't know what it is right now, what his obligation is. So he may be wrong there, and he's loading the dice in what he's telling the client. I mean, couldn't he have just, said the mother's got other lawyers. I'm going to go step by step here, see what those lawyers do, and not, because I find once we turn over the gun, once he turns over the gun, this thing is, it changes the whole case, and also what he can do about it, too. I mean, I don't know I'm not saying I know what the right thing to do is, but it just seems like he's oversimplifying that he had to turn it over. At least in California, he could have just let it sit there and let her be represented by another lawyer. He's saying CPCS would do that. I have no idea whether she could pay for one or not, but that would have avoided some of this mess, right?
So
again, I don't know what would happen next. That lawyer may feel the obligation, or the mother may decide on her own to turn it over. But this thing he's just, implicated in the whole he's overriding the mother's decision and his client's decision in certain ways, isn't he?
Well, first, I don't know that he's overriding the mother's decision. It seems the mother was wanted.
Well, the
that
mother,
gun
like anyone, is
out of
listening to lawyers at this stage of
Sure.
the game.
But, so I do think that if the facts were not precisely as they were in this case, as the California approach indicates, the attorney has not received physical possession of the gun. He merely knows its location, subject to the other exceptions of 1.6. Is it somewhere where it might pose a risk to someone, cause substantial harm? But generally, you don't have to disclose to the Commonwealth that you are aware of where incriminating evidence is located. But again, as Attorney Atwood explained, he was looking at the case as a whole, knew that, the specific location of the gun and the source of the gun was going to come up.
I get that, and particularly my more experienced colleagues in prosecuting these things, I understand the back and forth questioning is sooner or later going to get to this gun. It may, if he puts him on, he needs to put him on the stand. This is a self-defense case. I don't agree with your brother that you can, just because there's a phone there, you've got a self-defense. But I don't know how, I don't know how this proceeds at trial. Because he can certainly do a lot of the case. It's just when we get to the gun issue, then he knows facts that, he can't misrepresent the facts if he hasn't turned over the gun.
Right, and so knowing that this potential untruth left unaddressed might come out, he had to advise his client that you should not commit perjury on the
I'm not sure he
location
had
of the gun,
advised-
and that being the case,
I'm
it
not
now
sure he
makes
should
sense
have
to.
been advising his client at this point. I mean, I see the point that withdrawal is a disaster, because it just shifts it to someone else, but I
Right.
don't know whether he should be, I don't know, I'm confused by it, but it just seems like this is not meaningful consent when you load this up this way.
Well, even without meaningful consent, given the, overwhelming evidence of the case,
But how do we, don't we have prejudice here? I mean, again, that gun has a laser on it. That gun is, he stole the gun from somebody, which is a bad act, pretty incriminating bad act. That's in the case, right? Trying to remember what else we've got. There's other damaging stuff about the gun, too, that he's lied about it.
but the evidence was also that the laser sight and those attachments were on the gun when the defendant stole them. So it wasn't that the defendant had gone out searching to modify the gun to make it.
But he's pointing a gun with a laser on it, right? It's just your chances of killing someone with a laser are higher than without one, right?
Right, although there was testimony, and Attorney Atwood made sure to elicit several times while cross-examining the Commonwealth's witnesses that notwithstanding the presence of the laser sight, they never saw a laser light, a red dot, shining anywhere.
So what's your best argument? Assume confidentiality and assume informed consent doesn't work. What's your best argument that there's no prejudice?
Well, here, the defendant was on trial for murder in the first degree, deliberate premeditation, extreme atrocity, and cruelty. Again, even before you get to his numerous admissions to having committed the act, the evidence against him was overwhelming, established by the testimony of the victim's sister, her phone conversations with him, his text messages that I'm out here, the security guards, seeing the car leaving, returning later on with the victim running out in his flip-flops, where he was ultimately shot, the license plate reader at the entrance to the Ships Cove complex captured the defendant's car coming and going. When that car is later found in the driveway of the defendant's mother's home, there's forensic testing done in the car and gunshot residue is found inside. And then, of course, he goes on to make all of his admissions to having done it. And in that light, the sort of how he got a hold of this gun, what he did with it after the fact is sort of a side issue when the overwhelming evidence establishes that this was a killing done senselessly and only the defendant could provide the information or advance a self-defense claim through his testimony. Excuse me.
By the way, we don't have any findings from the trial judge on this, right? She just basically concludes there's informed consent. She doesn't get into the prejudice analysis. So we don't have any findings from her on this, right? Zero.
No, although, of course, obviously implicit in her denial of the motion is that she did not think the performance was deficient.
Well,
And thus, when there's no first prong.
She assumes there's no error because it's informed consent. She doesn't deal with.
That's her only sort of legal finding, but I would suggest her, given the tenor of her fact findings, she describes a very thorough, thoughtful, deliberative process underlying the decision to disclose. And again, she credits counsel's testimony that there was further discussion beyond just what's contained in this letter. And again, arguably, to go back to the argument that there's no prejudice, even if there was no informed consent, not only was the evidence overwhelming, and for a variety of reasons disclosure made sense, the defendant was not convicted of murder in the first degree. So that is some evidence on its own that the jury was not overwhelmingly prejudiced against him, because they did not accept the inferences the Commonwealth urged them to draw regarding deliberate premeditation and so forth.